Good morning, and may it please the Court.
Mr. Sullivan.
Thank you, Justice Spina. Good morning, and may it please the Court. Defendant Lynn-Rose Woodbine was convicted of first-degree murder in the death of Anston Thompson, who was found shot to death behind an apartment building at 37 Wales Street in Dorchester on December 15, 2003. Woodbine was found about a block away suffering from a gunshot wound to the thigh. He was arrested and taken to the hospital for treatment. The main evidence against Woodbine at trial was a confession allegedly elicited from him by Detective Daniel Keeler of the Boston Homicide Bureau the following day at the hospital.
Mr.
And
Sullivan,
three of the four issues on appeal relate to that statement. Yes, Your Honor, I'm sorry.
Going to that issue, it's a heroic effort, but how do we get around the credibility issue?
Well, I recognize, Your Honor, that this Court has said over and over again that, and let me say this, there were two bases for my argument that the motion judge erred in failing to suppress that statement. And one of them, I submit, was not directly addressed by Judge Fishman. And that issue is that there's no question that Woodbine invoked. There were three efforts to interview him. And the first effort, which was shortly after, was in the early morning hours of December 16th at the hospital. It is undisputed that Woodbine invoked his right to remain silent.
What time was that? Was that the 3
a.m.? It was it was somewhere between midnight and 3 a.m. Yes, Your Honor. Keeler and others other detectives went to the hospital. They tried to question Woodbine about this incident, and Woodbine refused to discuss it. So the first.
What did the judge find that he said? I don't want to talk about it right now, or
Judge Fishman found that he would not discuss the incident. I think that the testimony was, I don't want to talk about it now, or something to that effect.
Was the now part of that, or was it
well,
just I don't want to talk about it?
Well, I think the testimony was that now was in there, but he refused to talk about it. So my first argument, which I think and Judge Fishman did not directly address that argument, even though it was made below by trial counsel in the memorandum of law, is that by going back to the hospital later that day, Keeler did not scrupulously honor Woodbine's invocation. He's questioning.
But you cited Mosley with respect to that proposition, and in Mosley, it was less than 3 hours.
Well, it was, Your Honor, but in Mosley, it was a different police officer and it was a different subject. And here, it's the same police officer, the same subject. I recognize there's no bright-line test, but I think that you have here a pattern of acts which are, I submit, an effort to basically get this guy to talk. And I think that at least under totality of the circumstances test, you have to consider what does scrupulously honor mean when there's no break in custody, a person invokes their right to remain silent, and the same cop goes back again to try to question him about the same crime. It's not. I think it is. It's parallel, really, to the Edwards situation, and should be viewed as. I mean, what's the difference between invoking your right to counsel and invoking your right to silence? In both cases, you're saying you're invoking a constitutional right.
The courts distinguish between the two.
Well, they have, Your Honor. They have, and that's why we don't have a bright line test as we do in Edwards. We have a mushier totality of circumstances test. But I guess getting back to Justice Botsford's question, I don't think that Judge Fishman directly addressed that claim. The second claim, I do think I have. I do kind of am in the headwind of this Court's consistently saying we defer to the credibility determinations unless it's clearly erroneous. We're not going to overturn it, and I recognize all of that. And I think that here you have a pretty profound set of circumstances where you have the first time Keeler tried to question Woodbine refused to talk to him. The third time he tried to talk to him, on tape, he didn't tell him what he said could be used against him, and when he mentioned the right to counsel, Woodbine said, "Where's the lawyer?" He invoked. So now you have the second time, And what evidence is there other than Keeler saying, well, I gave him the correct Miranda rights from memory and he voluntarily waived? There's no Miranda, there's no signed waiver, there's no signed acknowledgement of rights. He didn't do it right. He invoked the first time, he invoked the third time, he didn't even get the rights right the third time. And I think it's problematic in those circumstances for a judge to say, well, based on his experience and based on the fact that he told me he did it, I'm just going to basically
Mr.
accept
Sultan,
it.
there's one, in the course of these efforts to get his statement, there's also, as I recall, Detective Keeler said that the defendant drew a diagram or something.
Correct.
If I got that right?
Yes, Your Honor.
Which interview was that? Was that the 3 a.m.? Was that the? I take it it's not when he said I don't want to talk to you. So it must have been the 5 p.m. the next day.
It was during the second, since the I believe it was during the unrecorded piece,
Portion of the tape.
the 15 minutes when Keeler and Woodbine were in the room alone. That's when Keeler said he drew a diagram, and Keeler, that diagram disappeared and nobody could find it because if it had happened during the suppressed piece, I don't think it could have come up at a trial at all.
So as I understand, part of your argument it was that the Commonwealth's position is that there was no written Miranda waiver. At least the police officer testified that the fellow had an IV or something and therefore couldn't sign the card. And your argument, or one of the things you point out, is, but that's during the same period of time when he supposedly drew a diagram.
Right. There's something inconsistent about saying he can't sign a Miranda acknowledgement, but he can draw a diagram. It's a bunch of circumstances.
I understand that, but I'm getting to one more point.
I'm sorry, Your Honor.
So shortly thereafter, they tape recorded this confession, which was suppressed. Right. In the tape recording, can you tell whether he's got an IV in his hand, or is it? I mean, I take it he was in the hospital bed when they tape recorded.
I mean, the only evidence about the IV came from the detectives who acknowledged that he had IVs, and I think Judge Fishman mentions that, I believe, in his findings. There's nothing in the recording that
you couldn't see in the recording whether he's.
It's not videotape, Your Honor. It's just an.
I'm sorry.
It's just
For
an
some reason
audio.
I thought
It's
it was
just an audio tape.
Okay.
So
Going to the audio tape, let's assume, for the sake of argument, that we find it clear that the detective, having already reviewed the tape recording, refreshed his memory with that tape recording in testifying at trial as to what was said before the tape recording. Is it your view that the suppression of the tape-recorded statement bars or sort of taints that in the same way as it would, say, under a Castigar kind of taint? Or what is your view as to how we should apply that?
Well, Your Honor, the only case I think that we could find on sort of these similar circumstances was actually an old Second Circuit civil case, which sort of said, well, you can't use you can't use the tape to basically to get inadmissible. You can't get inadmissible evidence into evidence by basically reviewing it and then stating it in court. I think it's more. It is. I guess it is kind of a fruit. I would argue it's kind of a fruit. It's more of a Wong Sung kind of a thing, or a Castigar kind of a thing. The defense counsel argued that he should not be allowed to consult it, that basically his testimony should be limited at trial to what it was at the suppression hearing, when all that he said happened during those 15 minutes was that he gave me a brief little thing in the beginning about what happened. That was his testimony at the suppression hearing. At trial, it became virtually a verbatim replication of what was on the tape.
Well, wait a minute. At the suppression hearing, 2 years before the trial, not only was there one paragraph, but he said, when asked by the prosecutor at the suppression hearing, what did he say? He says, I just off the top of my head can't recall exactly what was said here.
Yes, Your Honor.
2 years later, he goes into it in great detail.
In great detail. So, I mean, I think it's...
So was it explored at the time of trial where the memory came from?
Well, what happened at trial, Your Honor, was by the time the trial judge, Judge Hinkle, held a very limited voir dire with Keeler on this subject, he had already reviewed the tape. And he testified, basically, that everything he claimed to remember all of this detail, which at the suppression hearing, clearly, as Your Honor correctly points out, 2 years earlier, he had not remembered. So I think that it's the only possible inference that he was testifying at trial from the tape, but that sort of gets back to Justice Gantz's question, which is, what do you do with that?
Yeah, I mean, if it's been suppressed, can you even use the tape, like the banana will refresh your recollection? Can you use a bad banana to refresh your recollection?
Well, I think that's the issue we try to raise. I mean, there's a lot of law that says you can use anything to refresh your recollection, but where you're talking about here, because it was already suppressed, effectively the suppression ruling was circumvented because, as Judge Hinkle even sort of mused, the Commonwealth was having its cake and eating it too. The recording had been suppressed. Instead, they were getting Keeler basically said what was on the recording, and defense counsel was basically couldn't attack him on the contradiction between his lack of memory at the suppression hearing and his great detailed memory at trial because of all these warnings that, well, you don't want to, you might open the door, you better not open the door, and I think that was improper because once something is suppressed, it should be as though it never happened. It should be off the table entirely. It shouldn't be lurking like a cloud over the trial that if you ask the wrong question on cross-examination and you say to Keeler, isn't it true that 2 years ago you didn't remember what he said during that statement, that somehow opens the door, and now here comes the recording and the defendant
I'm
is
sorry.
cooked.
I'm sorry. You mean he couldn't be cross-examined about his grand jury testimony, where he said he couldn't remember it off the top of his head?
Because it would open up the tape.
Well, that was it was never explicitly put that way, but he was over and over again. The Commonwealth fought a motion in limine, which is in my appendix.
Let's be more narrow. Was he cross-examined on his remarkable memory?
No, Your Honor, he was not.
He was not, and he was not cross-examined or impeached with his prior grand jury testimony, which suggested a much more limited memory.
Not on that subject, no. The only cross-examination, the only impeachment of his memory at trial was one question to establish he did not take notes and he did not write a report. That was it.
What did he say substantively in the grand jury as to his recollection of, if he was even asked, as to the first unrecorded conversation in which the defendant related some details? Did he relate the details that the defendant had given him?
He did not, Your Honor. He said there was a tape, basically, and they played the tape. He did not relate it. He was not specifically asked, I think, to be fair, he was not specifically asked, what do you remember him saying during that period of time?
And was there I know that there was a police report, but did the police report contain anything about what the defendant had told him?
Absolutely not, Your Honor.
Because Keeler was alone in the room at the time the defendant was talking.
He was alone in the room. He did not write a report. He didn't take any notes. Then after he meets alone with the defendant, he brings in Callahan, and that's when they start the tape. And Callahan does write a report, and this becomes important in terms of the closing argument of the Commonwealth. Callahan's report simply says that Woodbine made a statement, see tape. Basically, that's the thrust of what's in Callahan's report about this entire interaction. There's no substance at all about what Woodbine said. And I submit that is grossly misrepresented in closing argument when, in order to try to buttress Keeler, the Commonwealth argues that there was a report. Callahan incorporated what Woodbine said in his report when, A, that's not, there was no evidence to that effect, and B, that's not even true, because in fact, as the prosecutor had told the trial judge over and over again during the trial in response to her inquiries, there was no report reflecting what Woodbine had said.
Wasn't there some testimony, and this is just a factual question, did Detective Keeler testify that before the tape, he repeated to when Callahan came back into the room, that he repeated to Callahan what Woodbine had just told him?
What he said, what he was allowed to say, the Commonwealth, the Commonwealth, their proffer to the court was that when Callahan came back in, Keeler basically repeated the details of what Woodbine had said. Judge Hinkle did not allow that testimony. Judge Hinkle simply allowed testimony to the effect that Keeler told Callahan that there had been that a statement had been made. Callahan's testimony, or I think it was Keeler's testimony, we went all over it again. That was Keeler's testimony, which was really not in response to a question, was stricken by Judge Hinkle. So the jury really never heard what was said at all between Keeler. Judge Hinkle's position, I think, was absolutely right, is that Keeler, these are Keeler's words to Callahan, and that could not come as an admission by Woodbine, although they tried to get it in as some kind of an adoptive admission, and she rejected that argument.
If I can go back to the so-called taint issue, what rule are you suggesting we apply with regard to the use of a suppressed tape to refresh memory? I mean, the problem, there's some practical problem, which is at the motion to suppress hearing, you may have the witness likely there, and the tape could be played at the hearing. So
it was played at the hearing. Yeah.
So it's, I mean, it's different from a Castigar type taint where it's grand jury and you can put it aside and hopefully nobody has seen it. But you don't have that same opportunity. So if we were to apply that, a taint type rule, it seems that we would almost always be making it impossible, or as impossible, or as difficult as under Castigar, to use the pre-recorded or that which was said before the suppressed portion. So what rule should we apply?
Well, I think it is a practical problem, because I think obviously until the judge rules that the tape is suppressed, it's perfectly appropriate to have it as part of the evidence of suppression hearing, and it's perfectly appropriate, I suppose, in certain circumstances to play it with Keeler, the witness, on the stand. But I think the rule should be that once something is suppressed, it cannot be used for any purpose. And if Keeler can remember from the suppression hearing 2 years earlier what was on that tape, and he still has that in his head 2 years later at the trial and manages to testify that way, there's really nothing that can be done about that. But he shouldn't be permitted to, the night before he testifies, sit down with that tape, basically ingest its contents, and then spit those suppressed contents out to the jury the following day. I mean, that is such a blatant circumvention of a suppression order that it really, it sort of, it just kind of, it denies the defendant the benefit of this evidence being excluded, because it was illegally obtained. It was illegally obtained, but it somehow came in the back door. And I think there are some logistical issues about how you formulate a rule, but there should be, whatever the rule is, it should not allow what Keeler clearly did in this case.
Is the problem here that the judge should have given the trial counsel a little more leeway to cross-examine Keeler about prior limited knowledge without thereafter declaring that open season on?
Well, Your Honor, there should have been no question about opening any door. I mean, there's really nothing that should have happened that would have opened the door in this case, other than the defendant taking the stand, in which case it's settled that he can be impeached with his prior inconsistent statement. The judge, there should have been no question about opening the door. Why should anything open the door? The trial counsel should be able to impeach Keeler fully and vigorously. This was the central evidence in the case about the inconsistencies between his great memory at trial and his failure of memory 2 years earlier. That should have been the focal point. I mean, that's the only chance the defendant has in this case, is if the jury has a reasonable doubt about Keeler's testimony, and that was basically taken away from the defense by the judge's repeated warnings, be careful, don't open the door, and the defense lawyer basically went to the other side of the room. He was being so careful. And so Keeler got a free ride. If I could just my 45 seconds I have left on this juror issue, and I understand that trial judges have enormous discretion in excusing jurors. In this case, I think that this just went too far. This was a 14-year-old failure to obey a police officer case, and which was not disclosed on the jury questionnaire. And I apologize for not putting this in my brief, but it's not even a crime. I mean, this is a civil infraction under Massachusetts law. I think it's Chapter 90, Section 25. So she did not err in failing to put this on her jury questionnaire because it's not a crime. She wasn't charged with a crime, and she should not have been kicked off. And when you kick somebody off who belongs in the panel, you're essentially, it's like a deck of cards. You're taking something out of the deck.
Could you just explain when that happened? And
It
was
hap-
during impanelment, is that right?
It happened during impanelment, and I think it was
Were there
begin-
still peremptories left on
Yes,
the
Your Honor.
Commonwealth side?
There were still peremptories left. They still had 5 peremptories left. I think it was the second day of impanelment. They had just run the records. The Commonwealth had run the records between the first day and the second day. So they still had peremptories left. She was excused for cause. Judge Hinkle specifically said she excused her for cause because she did not disclose the fact that she had been charged with a crime, and she hadn't been charged with a crime. The defense objected. And while Cousins, now in every case under Cousins, it's sort of open season on checking jurors' records and kicking them off. But, you've got to draw a line. And this was just something that should not have been allowed to happen. This juror should have been part of the group who was in play for ultimately the selection of the jury. And I think when you change the makeup of the deck, you're affecting the ultimate way the jury, the selected jury.
Did the Commonwealth use all their peremptories?
I'm sorry, Your Honor?
Did the Commonwealth use all their peremptories?
They had 5 left at the time this happened. I don't remember, Your Honor, whether they ended up using them all or not. I can't.
Did the defendant use all of his?
I don't know the answer to that, Your Honor. I apologize.
Thank you.
Thank you, Your Honor.
Attorney Lee?
Good morning. May it please the Court. My name is Macy Lee. I'm an Assistant District Attorney, and I represent the Commonwealth in this matter. Let me begin by saying that I think that there is no question that there is a lot of nooks and crannies in this case.
A lot of nooks and crannies? I'm sorry, I
Yes.
just couldn't hear you.
Yes. But despite all of it, there is no grounds for reversal in this particular case. I will start off with Justice Cordy's last question concerning possible taint in Detective Keeler's testimony. Justice Gant's question. There's absolutely no evidence to that effect. If you compare the transcript of Detective Keeler's testimony in the suppression hearing, he testified that he had just come off of testifying in another homicide case, that he had not reviewed the file, but he was able to testify to the defendant's statement nonetheless. This is the unrecorded statement. In his testimony, he specifically stated that the defendant told him that he wanted to speak to him alone, that he owed someone money, and that this was his chance to repay, and that he was in the car with a man named Hooker. That was the extent of his testimony. His testimony at trial consists of 10 pages of the defendant's statement, and it essentially said the same thing. If you read the...
Well, it says a little more.
It does say a little more. It does. It talks about the .44, the weapon that was involved, which is...
And the shooting.
And the shooting itself, yes, in the bushes. There's definitely more detail about it. But if you look at the transcription of the recorded statement by the defendant, it goes into far more detail. It talks about the cars, the type of car he was in, the person who was driving the car who dropped him and Hooker off at Wales Street. It's far more greater detail that Detective Keeler did not go into. So I don't think that there's any evidence whatsoever in the record to support any suggestion that Detective Keeler's testimony was tainted by suppressed evidence.
So why did he listen to the tape the day before trial?
I don't know.
And he knew the evidence had been suppressed.
I agree with you on that.
I mean, is the only reasonable inference that we can draw from the record that he used it to refresh his recollection?
Again, I think if you take into...
No, that's my question is, can we infer that he used it to refresh his recollection?
No, I think you can, but I think that the inference would not be supported by the record in its entirety. Again, going back to suppression...
What if it had assisted his memory?
Then I think if it did, I think that it's still not grounds for reversal, because here, although there's no question that the defendant's testimony was crucial in this case, it was not the only piece of evidence of his participation in the murder. The ballistics evidence in this case is particularly strong, where it indicated that 2 weapons were used at the murder scene. And one of the casings that were found at the murder scene matched with the gun that the security guard, Mr. Baptiste, testified seeing the defendant drop. So there is strong ballistics evidence that he was at the murder scene. That
And the
gun,
defendant's blood was also on the gun.
exactly,
yes.
and there's his DNA is all over the weapon, the murder weapon. So notwithstanding this statement and whether there's any possible suggestion of taintness, there's strong evidence in this case to tie the defendant to the murder.
How many shots did Mr. is it Thompson, the victim?
Sustain?
Yes.
I think 9. Many in his hand, and several of them could have been crucial. One to his head that could have been crucial to his life.
And do they know? Do they know? The answer is probably no. But is there any? I know there was a bullet or maybe 2.
Yes.
But
Yes.
but the fatal wound or the one that could have been fatal, which I think went through the spleen.
Yes.
Any connection of
Yes,
a
that one
bullet
was
to
tested.
that one?
Yes, to match the weapon itself that was
The
found.
357?
Yes. In fact, I think there were 3 that they were able to extract that matched the weapon that was found. I think it was on Wales and Nightingale Street. So yes, so there is definitely strong evidence, notwithstanding the defendant's statement. Even without the statement, there is strong evidence, overwhelming evidence of his involvement in this particular murder. Unless there's any questions, I'll move on to the Miranda.
I actually wanted. Okay,
Yes.
I want to ask you at some point though about the argument that about Detective Callahan's report, because you never in your brief, at least that I saw, sort of take on the issue of the fact that what was represented to the judge before the closing argument was there was nothing. It didn't say anything, and then the closing argument presents quite a different picture.
Well, I respectfully disagree with you on that. The prosecutor properly responded to the defense closing argument that there was absolutely no documentation of what occurred in the hospital room. And Detective Callahan did testify that he was the detective that was charged with the responsibility of drafting all the reports surrounding all the interviews in this particular case. And when the trial prosecutor asked him whether or not he had wrote a report concerning what occurred in a hospital room, he specifically answered yes.
Yes, but
I agree. I don't know what the contents are. I've never seen the police report. I don't know. But the trial prosecutor did not argue.
the contents are he spoke, see the tape.
But again, that is documentation, and the trial prosecutor here did not go into the details of what was recorded. He did not say that he recorded the statement, that the defendant said X, Y, and Z.
But isn't the point that he implied that all those things were
Perhaps,
in there?
but again, it's closing argument. And based on the curative instructions that were given by Judge Hinkle before closing argument and after, there was no objection as well by defense counsel. So.
Would it be different if he'd said that there were things in it that there weren't?
Absolutely.
You're saying the difference is in strong implication versus the outright lie.
Absolutely. I mean, inferences can be made by the arguments, but again, the trial prosecutor never once said in his closing that they're given any of the details. I mean, yes, there was documentation as supported by.
Is there any other inference possible from this statement? I couldn't see one.
I don't believe so. No. I mean, the only one that I can tag on was Detective Callahan's testimony, and he did say that he documented it. I don't know in what way, in what manner, in what substance, but he did. And the trial prosecutor did not argue the substance of any reports that were.
I mean, the trial prosecutor said Detective Callahan incorporates what the defendant said.
Yes, and Detective Callahan did say that he wrote a
on the
report.
suppressed evidence.
Right.
I mean, it's just.
Well,
I'm troubled that you don't even address it. Frankly.
Well, I don't think it's on the suppressed evidence because at trial, Detective Callahan did not testify at the suppression hearing. Should he have? Perhaps. That would have been extremely helpful, I believe, in this particular case. But he did testify at trial that he was present, that he exited the hospital room for about 10 to 15 minutes while Detective Keeler spoke to the defendant alone, and that he returned, and there was a recitation of what occurred, and he testified that the defendant nodded, yes. So he was there, and then after that he said, yes, I did write a report about what occurred in the hospital room. As to what occurred, I don't know. So that is not the suppressed evidence. That is actually the unrecorded statement that Detective Callahan was referring to.
But his report doesn't reflect that, does it?
I do not know because
Is the report not in the record?
I believe it's not. I looked for it and I could not find it.
Isn't aren't we talking about the report that Mr. Sultan is describing, the one that says see tape?
Yes, so I think it does say C tape, but like I said, I don't know in terms of what other statements were in this.
So if we were to look to see whether it was misleading based on that report, we can't do it because we don't have the report.
Right, that's correct. I will try to obtain this report from the court, but I could not find it myself to verify what was actually in it. But nonetheless, regardless of what was actually in the report, again, the trial prosecutor did not go into the substance of the actual report, and there's curative instructions firmly instructing the jurors that this is for argument's sake and that their recollection of the evidence is what holds and not what's argued by either defense counsel or the trial prosecutor. Moving to the issues concerning Miranda, the motion judge's findings stand here. There's this finding of credibility, although Detective Keeler did not recite the full Miranda warnings on cross-examination. Nonetheless, the motion judge properly found that given the entirety of the circumstances, the Miranda warnings were fully given prior to the unrecorded statement. And I think if you look at all the circumstances, especially in his direct examination during the suppression hearing, he did recite all 5 requisite rights.
How old is the defendant? Is it part of the record?
No, I don't know. I know the victim was 31, so I don't know. I imagine that he was in his 20s, if not early 30s. But there's no evidence that it was, that any waiver after the full Miranda rights were in any way involuntary. I think that reflects it in obviously the recorded statement, but not in the unrecorded statement.
Is it the case that the evidence at the motion to suppress was the detective testifying that the reason the defendant didn't sign a Miranda waiver was because he had an IV?
That, I'm trying to remember if that came up during the suppression hearing. I know at trial, Detective Keeler testified several times that he did have an IV in his arm. That is in the trial testimony.
Okay.
I don't believe it was in the suppression hearing. There was a lot of claims that he did not recall the circumstances.
But that was the same interview, I take it, in which the detective says he drew a diagram of
Yes.
some sort, which has not been found.
Yes, it was during the unrecorded statement that he did draw the diagram, which has not been found and is also used again in the recorded statement. So if you read the transcript of the statement, it was refer to it. So yes.
Well, the transcript of the tape-recorded statement refers to this diagram.
It does.
So it did exist at some point in time.
It does, because he refers to it again in terms of where he drew the X's and where he was located prior to the shooting.
And would you concede that if, in fact, he could draw a diagram, he probably could have signed a Miranda waiver?
I don't think there's any way that I cannot concede that. So, unless the court has any further questions, I just want to leave the court with the defendant should also be denied any relief under 33E. The victim was shot unexpectedly during his celebration of his 31st birthday, and there are no grounds for reversal otherwise.
Would you like to say something more about the juror issue?
The juror issue, there is, again, this was an impaneled juror. The trial judge was well within her rights to dismiss this juror in the interest of justice. This was a juror that did...
I can't remember. Did the Commonwealth actually move, or was the juror to have this juror dismissed for cause, or was it just the judge?
The trial prosecutor did move for cause, for dismissal.
Well, if, I haven't looked at it, but if Mr. Sultan is correct that it isn't even a crime, does that make a difference?
But it doesn't require that it be a crime. The question, in my understanding, is that any involvement with, I forget the exact language, but any involvement with criminal.
It was not an accurate answer to the question.
Exactly. I don't have the exact, it's in my brief, the exact language of the questionnaire. But either way, the trial judge was well within her rights, because she can easily presume here that if she could not, this particular juror, follow instructions of answering a jury questionnaire, that she may not follow instructions throughout the trial, and that's well established in Cousins. And the language is not criminal; it's not convictions; it's criminal involvement. I believe that's the language under the jury
But if it isn't a crime, it's not criminal involvement.
That again, it doesn't ask for specific convictions in the jury questionnaire, that I recall. Thank you.
No other questions? Thank you. Sorry.